Good morning, everyone. This is Rajeshkumar. Today, we are going to analyze one problem question on agreement. Disclaimer: the video content has been made available for informational and educational purpose only. Kindly go through the disclaimer completely. Problem question: Lady Amity, an eccentric old lady, has now decided to sell one of her hotels to pay for the new roof on her house. She places the following advertisement in the Times newspaper. Exclusive hotel for the sale by tender. Terms and envelopes for submission available. All tenders to be received by midday of 1st of February. On 30th January, Lady Amity receives two tenders in the prescribed form. When she opens the first tender, see, see it is from Brash, the current manager of the hotel, whom Lady Amity employs. She immediately throws it away, muttering about servants not knowing their place these days. She is so annoyed that she forgets about the second tender from Clarissa, a well-known chef. On 5th February, Lady Amity receives an email from Devi, a local business woman, who says she heard that the hotel was for sale and that she might be interested in buying it for around 1 million, but that she will need to do a profitability survey before committing herself. The letter agrees that for a fee of £1,000, Lady Amity will not offer the hotel to any other party before 1st of March. Devi pays £25,000 to Enterprise Co. to do a profitability survey, which is very positive. On 18 February, Frederick phones Lady Amity while driving his car and offers 11 million for the hotel. Lady Amity says, "Yes, that's a deal." But Frederick does not hear her because of the loud road noise. He decides to ring again when she stops for petrol. Lady Amity immediately rings Devi and tells her the hotel has now been sold. While driving, Frederick thinks he has offered too much for the hotel. At the next petrol station, he rings Lady Amity and tells her he wants to buy a hotel for 10 million. So we have to advise a Lady Amity. To advise a Lady Amity on her obligation and options, we need to analyze her interaction with each potential buyer regarding the contract, formation, and acceptance, with a particular focus on the legal principles of tenders and agreement. Amity's advertisement, is it an invitation to treat? In Times newspaper, her hotel sale by tender indicates that she invites the offers from potential buyers rather than making a binding offer herself. Based on the Gibson versus the Manchester City Council, an advertisement for tender is typically viewed as an invitation to trade. This distinction means that she is not legally required to accept any specific tender, but has instead initiated a competitive offer process. Cases such as the Blackpool and Flight Aero Club versus Blackpool Borough Council and Harvilla Investment versus Royal Trust Co. of Canada provide further guidance on how handling of tenders, obligations surrounding the fair treatment, and the limitations of the tendering process. Let's start with the first one, brash tender and Lady Amity's rejection. Whether the Lady Amity has a legal obligation to consider a brash tender. A Lady Amity decision to discard a brass tender without consideration highlights the importance of the procedural fairness required in tender process. In Blackpool and Flight Aero Club versus Blackpool Borough Council, the court found an obligation to consider all tenders submitted in compliance with the terms. Here, Brash followed the correct procedure and Lady Amity's failure to consider his tender may constitute a breach of the implied duty of fairness in the tender process. To conclude, the Lady Amity may have breached her obligation to consider a brass tender by discarding it without review. While her emotional reactions may explain her action, the legal implications remains that she should have considered all tenders submitted according to her advertisement terms. We move on to the second item, Clarissa tender and the Lady Amity failure to act. Clarissa tender was submitted as required and should have been reviewed by Lady Amity. A Blackpool and Flight Aero Club versus Blackpool BC reinforces that an invitation to tender imposes a duty to consider all complaint tenders. Blackpool and Flight Aero Club versus the Blackpool BC reinforces that an invitation to tender imposes a duty to consider all complaint tender even if there is no obligation to accept any of them. Since Lady Amici forgets to consider Clarissa tender due to her distraction with Brash, she potentially breached this implied duty by not assessing both attenders fairly. To conclude, the Lady Amici omissions in reviewing the Clarissa tender may again constitute a failure to act in good faith in the tender process, limiting her ability to proceed without a risk of a legal challenge from Clarissa. Let's move on to the third one, agreement with Devi for exclusivity. Devi's email expressing interest coupled with the payment for exclusivity constitute a unilateral contract where Lady Amity agreed not to offer the hotel to other parties until March 1st in exchange of Devi's £1,000 fee. The payment forms a valid consideration, making the agreement binding. It's based on Power On versus Loving Long case. To conclude, Lady Amity is obligated to honor the exclusivity agreement with Devi and subsequent agreement with Frederick to sell the hotel breaches this contract, making her potentially liable to Davies for any losses incurred due to her failure to honor the exclusivity agreement, especially given Davies' reliance on the exclusivity with her £25,000 survey investment. Acceptance and miscommunication with Frederick, whether a binding contract was formed during Lady Amity's initial conversation with Frederick. The Frederick's initial offer of 11 million and Lady Amity's acceptance faced challenges due to Entos versus Miles Forces Corporation case, which establishes that acceptance must be effectively communicated. Here, the Lady Amity verbal acceptance was not heard by Frederick due to the road noise, means no contract was formed as the communication was incomplete. An offer must be unambiguously accepted for a contract to be enforceable. To conclude, no contract was formed from Frederick's initial offer of 11 million because the acceptance was not communicated. Lady Amity is therefore not bound by this initial conversation. Frederick's revised offer of 10 million. Whether Lady Amity is bound to the new offer of 10 million from Frederick despite the exclusivity agreement with Davy. Frederick's call at the petrol station revising his offer to 10 million constitute a counter offer that negates his original offer of 11 million based on the case law Hyde versus Wrench. Although a Lady Amici could technically accept this counteroffer if no exclusivity agreement existed, her binding agreement with the Devi prevents her from negotiating with other parties until March 1st. Any sale to Frederick before this date would likely breach her contractual obligation to Devi. To conclude, Lady Amity cannot accept Frederick's revised offer without violating her exclusivity agreement with Devi, potentially leading to a liability for a breach of contract. Final advice for Lady Amity. A brass and Clarissa teacher tenders, a Lady Amity failure to review these tenders may expose her to claims for unfair treatment. She should avoid discarding tenders in similar future scenarios to maintain compliance with the procedural fairness as per Blackpool and Flight Aero Club versus Blackpool BC. The exclusivity agreement with Devi. The agreement with Devi creates a binding obligation to refrain from selling or offering the hotel to others until March 1st. Lady Amity must honor this commitment as any further negotiations or agreements could result in final liability. The interaction with Frederick. No binding contract exists with Frederick due to the failed communication of acceptance for the initial 11 million offer. Frederick's subsequent offer of 10 million is also unenforceable as Lady Amity exclusivity agreement with Devi precludes her from accepting it. Lady Amity should honor the exclusivity agreement with Devi and refrain from further discussions or negotiation about selling the hotel until March 1st. So, this will avoid the potential breaches of contract and uphold the integrity of her initial tender process. Thank you.